And we have a team of experts who have been watching this trial, and we'd like to bring them in now. First, we'll introduce Tanya Cross-Phelan. She's the Associate Dean of Academics at Cooley Law School here in Michigan and has been teaching at the college for 20 years. She's a grad of Ferris State and has worked as a criminal defense practitioner and assistant public defender. Also joining us is Andrew Rodenhouse of Rodenhouse Law Group. Andrew is a trial attorney and graduate of Hope College. He received his Juris Doctorate degree from Cooley Law School and oversaw the appeals in the case of People versus Ackley, which changed Michigan law as we know it. And finally, we have Sarissa Montague. She's a criminal defense attorney with much experience in providing defense for those who are unable to afford their own. She is highly regarded as not only an exceptional litigator, but also an empathetic counselor. All three join me now. Thank you so much for joining me again, everyone. A lot has happened. I want to jump straight to Andrew because, Andrew, we talked to you before this motion. These two motions were filed. What is your reaction just right off the bat?
Exactly what I anticipated. I know that some people were like, "Wow, how did he predict that?" It's like, well, every person who's ever tried a case could have predicted that. And so it's a very common thing to ask for a directed verdict. What's more uncommon though is, and we can talk about the motion for a mistrial, and again, it's kind of a different iteration on what they've been claiming all along about these experts. The one expert that I was watching yesterday and it continued this morning, they were talking about what officers need to do, and the motion that they brought was based upon a Supreme Court case where it says that officers aren't held to any different standard than lay people, but what the Nick Bloomfield said is that officers need to articulate the reason why they did this. Well, how does that mesh with your right to remain silent? What if Mr. Schurr decides he wants to remain silent, and now all of a sudden we've had an expert say that he has to take the stand? I think what he's referring to is what's known as a Garrity statement, which if you rewind all the way back to Monday, I had mentioned that officers typically are required to make a statement, but that those statements are internal, that they're not public, and that those statements are confidential and only get used if the officer takes a stand and testifies differently than what statement he made initially to his superiors. So that was just my kind of takeaway on it.
And Tanya, I want to bring you now in. What is your reaction to seeing these two motions filed? Are you surprised? Did you see it coming like Andrew? What are your thoughts?
Yes, good afternoon. Like Andrew, I fully expected the defense to move for a directed verdict. That is very common in criminal cases. And the judge's analysis went along the lines that I think we all anticipated it would, whether or not taking the light in the evidence most favorable to the prosecution, could a reasonable jury find that the elements had been satisfied. So when she was talking about those 3 points, death, causation, intent to kill, and lack of justification, she's really referring to the elements of the crime that the prosecutor has the burden to prove beyond a reasonable doubt. So that's how those two concepts connect together. So I wasn't surprised by that. What is more uncommon is to see a motion for a mistrial at the same time. However, the basis for that motion for mistrial is consistent with the legal arguments the defense has been making for quite some time, both pre-trial, during testimony, and at the conclusion of the prosecutor's case. So their argument against the experts the prosecution put forth has been consistent from the get-go. And I want to point out, I think it's really important because a lot has been made of this so far, is when we're talking about those two experts referring to national standards of police, what's reasonably accepted nationally, that's a very different concept. And the reason they're fighting so hard against that is because when we look at the elements of self-defense, it's not about a national standard. It's about this particular officer and what he was thinking at the time subjectively, and was it reasonable for him to think he needed to use deadly force. So when Ms. Hamilton was making the motion for mistrial and was referring to Supreme Court case law, for the judge to take a swipe at her, saying, I think it's ironic that you're now referring to national standards, was really mixing apples and oranges. And I'm glad that that was outside the presence of the jury, because that could have been seen kind of as a negative slapdown of the attorney. When we're making legal arguments as lawyers, we do refer to the Supreme Court because it is the law of the land, and Michigan law regarding the law has to meet those standards set forth by the Supreme Court. So I just wanted to make that point, that those were apples and oranges.
And I also want to bring in Sarissa. Sarissa, after watching and seeing those two motions filed, what was your initial reaction to that?
I agree with both Andrew and Tanya. It is very common, if not expected, for a motion for directed verdict to be filed. We have to do it in every case. And I think Tanya's analysis of the motion for mistrial was interesting and kind of spot on. You know, as lawyers, what people need to remember is that we're fighting the case for what we want to win at every step of the way. We're filing stuff because we want to be successful. And the other thing that we're doing, though, is creating a record. And that record is going to be used, God forbid, there is a conviction. And I say, God forbid, if you're on the defense side, you know, if there's a conviction, that record is then going to be reviewed by higher courts, the Court of Appeals, the Supreme Court, whatever it might be. So it's very important for us to make sure that we cover everything that we need to be doing as effective lawyers to make sure that we're protecting our client both in the courtroom and then in the future courtroom, should that be so. You know, that's a reason to do a directed verdict. It's a reason, again, we want to win. We're filing it because we're hope that we're successful, but if not, it's also something that helps down the road, should there be a down the road.
And Sarissa, I want to ask you about the appeal process and building that case, even in this current trial. Is it something where once the motion is filed, that anything that happens after that motion is used or solely focused on for the appeal? Is it the whole entire process? I guess, can you explain to us how you're able to build that case once that file is motioned for the appeal?
Sure. So it's not specific to that motion, okay? Whenever there's a case, and if a defendant loses at a case and they lose at trial, they have an automatic right to appeal their loss. And so it goes up to the Court of Appeals. And what the Court of Appeals does is reviews the entire record of a case. That consists of what happened pre-trial and what happens during trial, right? So there's not another trial at that point in front of the Court of Appeals. The Court of Appeals never gets to hear live testimony. So what the only thing that they can do is review the record. And again, that spans for the entirety of the case. And so that motion is part of that record. And maybe there was a problem that should have been addressed. And it's possible that, you know, the trial judge makes a ruling in a certain way, and it's possible that an appellate court might see the same issue a different way and come out to a different conclusion. And so you have to make sure that a record is very, very strong so that the Court of Appeals, again, you never want a case to get to the Court of Appeals, but if it does, you make sure that that record is as strong as possible so the Court of Appeals has what to look for.
And Tanya, I want to go back to you because you were able to confirm to us very quickly that the jury was not in the room when those two motions were filed. But I wanted to ask, does this put anything in perspective for the jurors? Does this make them sway either way? Or even have they even heard the filing of the motions? I guess, how does this impact what the jury is now thinking?
A great question. These types of motions are specifically held outside of the presence of the jury because we don't want the arguments that we're making legally to sway what they're hearing and what their decision-making process will be. Because in a trial, the jurors determine the factual outcome. The lawyers and the judges deal with the legal issues and analysis outside of the presence of the jury, again, for the specific reason that we don't want it to impact their factual determination of the case.
Got it. And I wanted to ask you, Andrew, about the comparison of a mistrial versus a direct verdict, I think there's some questions of, are they the same thing? Do they, filing at the same time, does that kind of like zero them out? Or I guess, is there really any comparison to each other if they're filed at the same time?
Well, that's there's a big distinction between the two. And so if you get a directed verdict, what that means, it's a directed verdict of acquittal, and you can't be retried again because jeopardy attaches. Versus if it's a mistrial, it would depend on who caused the mistrial. If it's just a general mistrial, then we would start the process over. We would correct whatever was wrong, and we would do it again. Pick a different jury, do a lot of different things. If it's caused by the prosecution, then it can result in what would essentially be a mistrial with prejudice attached. And that would act as if it was a directed verdict because jeopardy would have attached, and then you couldn't be retried for it under the double jeopardy rules. And so there's a distinction. It's possible you could end up with the same outcome. The most likely outcome, had the court granted the mistrial, would just simply have been a new trial. And that's why courts are loath to do it. I mean, it makes sense why Judge Mims would say no. She's already ruled on this a couple of times. It's important for appellate review, because the last thing you want, the worst thing that you can be as a trial lawyer is to be found by a court to be what's known as quote unquote ineffective. And if you're ineffective, man, that follows you around, and people know about it in the legal community. And so you do everything you can. Like Sarissa said, you're fighting, and you're going to file, move, whatever you need to do to prevail. And the worst thing that can happen is the Court of Appeals says, oh, if he had only raised that one objection or only done that one thing, then we could have ruled in your favor, but you didn't. And so, oh, you were ineffective. And that's not something anybody wants. And
so in your opinion, is it okay to file more than one motion versus like a mistrial and a direct verdict? Okay.
Yeah, in fact, in criminal law in Michigan, there's no such thing as a frivolous motion. You can challenge every aspect of the prosecution's case. Where in civil court, you file a motion that the court's like, there's no way you had a chance of winning. Why are you filing this? You're just making everyone do work. The opposite is true in criminal court. You file as many motions as you want, just simply because it's the prosecution's burden and the stakes are so high. So there's no such thing as a frivolous motion. And I'm not saying that these two motions were frivolous. I think that they're well-grounded motions. But there's a reason you do it.
And Tanya, I want to ask you, we saw the defense brought these motions on after the prosecution rested their case. On the flip side, is the prosecution also allowed to ask for a mistrial or a direct verdict once the defense rests their case? And what is that process like?
Well, certainly a prosecutor can ask for a mistrial. It's very rare, at least in my experience, it's very rare for a prosecutor to ask for a mistrial, but they can. And it would be very similar to what we saw play out in this particular case, but they would be alleging some kind of wrongdoing on the side of the defense, or the defense introducing evidence that somehow prejudiced the jury and how they would listen to and deliberate about the facts that had been presented.
And Sarissa, is it risky to file these motions at this time? When I hear the possibility that if I put together a direct verdict motion and it's approved and it doesn't go my way, to me, that scares me. But obviously, I'm not a lawyer, so break down maybe the risk factors of these motions.
Yeah, there's absolutely no risk to the defendant by filing those motions. I guess the only risk would be, irritating the judge. But every judge, every trial judge expects that at the close of the prosecutor's proof, the defense is going to file a motion for directed verdict. It is just going to happen. It is going to happen pretty much in every single case. And if it doesn't, then the lawyer, unless there's extenuating circumstances, the lawyer's kind of at risk of being found ineffective, like Andrew just said. So there's no risk at that at all. And as for the motions, there's no risk in filing motions. And in fact, if something else came up that the defense thought was problematic, they could file another motion for a mistrial. Or they could have filed 4 motions for mistrials if they had different reasons to, upon which that they were based, right? So there's no risk at all. You hope that maybe one will be successful. I don't know that you expect that to happen, but you certainly hope each and every time. But no, there's no harm done to a defendant by filing motions that are legitimate. There's just no harm done with that.
And Andrew, I want to ask you about the timing of all this. To some of us in the newsroom, it felt like it was very quick. It was like the jurors left the room and the defense got up right away, made their claims. I think we even heard the prosecution maybe say they didn't have a copy of the motion, and then the judge say that they already had the motion and were ready to talk about it. We were thinking that if they did decide to do this direct verdict, that it would take some time. Is that normal to see that happen that fast?
In fact, the normal is that you don't even file anything. The normal is you just orally make a motion at the close of the prosecution's proofs. Everyone knows it's coming. I mean, there's like Sarissa said, I mean, you do it in every case. So everyone expects it. And most times people don't actually file a formal written motion. You make an oral motion on the record. And the court reporter, takes the motion, and the judge listens to it, and the prosecution responds, and it's usually fairly quick. And sometimes you're just doing it just to preserve something for appellate reasons, and you don't expect to prevail. So it usually doesn't take, in most trials, it takes less than 5 minutes to make the motion, and maybe 10 minutes to have the judge hear the opposing side and make a ruling. So it doesn't take very long. It doesn't cost the court a lot of time, and they understand that every attorney has to do it.
And we spent a lot of time on these motions. I want to move to the next testimony that we saw, which is the first witness for the defense. During that time, we saw almost not a scuffle, but a discussion rather about some evidence being admitted in, like as they were going through the clips from this witness. Tanya, can you break down essentially what happened, what the complaint was, and then why they decided to ultimately not do what they did?
Well, yeah, so this is really interesting, and I'm really curious to hear what Sarissa and Andy have to say about this. But what the defense was trying to do with this particular video expert was to slow it down so that the jury could slow it down and magnify in certain points what exactly was transpiring, how the two were positioned relative to one another, what was happening with the taser, all of that. Because although we saw a lot of the video played during the prosecutor's case, it wasn't slowed down to that degree. And the defense really needs, I think, for their argument, for the jury to be able to see pinpoints in time and pinpoints in behavior. And the other thing that the defense expert, Mr. McFarland, did with the videos that we did not see in the prosecutor's case is that we now had a transcript running alongside of it, and they were put simultaneously, right? They were put together in a way that they were running at the same time. Now, why the prosecution objected, I think, is twofold, really. I think they were objecting to it being cumulative, which is an objection that can be made. It's a legitimate objection where the party is saying, look, judge, this is cumulative. We're just going over the same thing again and again and again. And then that ties into the second part of the objection, which is this is wasting the court's time. The defense responded by, hey, wait a second. We're allowed to put on a defense, and our expert is doing this in a particular way that is going to show what we're trying to argue on defense. So that was a really common objection on both sides. What bothers me about what happened, and again, I really want to hear what Sarissa and Andy have to say about this, is this argument that they can't make it while they're doing it. It is very common. I don't know how many trials I was involved in where the prosecution is having witnesses mark exhibits, draw on diagrams, and everything like that in real time. And to a certain degree, that's what the defense was doing here. What the judge ultimately ruled was, hey, I agree, we shouldn't be making these exhibits as we go. have your expert go ahead and show what you want it to show, bring him back in, and we'll introduce the exhibits that way.
And so I have to ask you real quick. I do want to hear from Sarissa and Andrew, but what is your reaction to that? I mean, if that was you and that's the decision you made, are you now frustrated because you're feeling like you're not able to make your case?
Well, for me, no, that would make me more determined to then, when we take the recess, that I'm going to go and have my witness actually do what the judge said he could do, and we're going to bring it back in and we're going to make the best of it. So I think most trial lawyers on either side of a case, we're prepared for those contingencies. Okay, what happens if the judge doesn't let it in? How am I going to get around it? How am I going to try to come at it at a different angle?
And Sarissa, I want to hear also your response to all of that happening here today.
Excuse me. I actually thought it was really interesting that the defense was trying to get the evidence in the way that it was doing it. And Tanya, I understand what you're saying. It's not so different from marking an exhibit. I mean, that happens all of the time. People draw on maps, or they mark a place on where a car was, something like that. That happens all of the time. And what's interesting is that this is kind of a modern day way of doing that, but it is slow. And so I thought it was a strategic decision. I thought it was a strategic decision, and I could be completely wrong on this, but this is what my take on it was, that the defense was making a strategic decision for some reason to try to get the evidence to the jury in the way that it was trying, through the expert sitting on the stand, creating the exhibits as they went forward in open court. And the strategic decision is, why did they decide to do it that way versus having these exhibits prepared in advance, just like the judge now has told them to do, and they're going to go and they're going to do it? Why didn't they do that initially, right? What was the decision making in trying to proceed in the manner in which they did? So that's what I found as striking. Again, maybe I'm wrong, but maybe that it would, but maybe there was a different reason for it. But that's how I took it. And they're going to go back and they're going to make the exhibits, and it's going to be perfectly fine. They're going to come in and they're going to show the stuff to the jury. The judge didn't say you can't do it. The judge just said you can't do it in the manner in which you are trying to do it. It's taking too much time, right? And so they were prepared for that. The defense had, I'm 1,000% confident that the defense was prepared that the judge might rule that they couldn't proceed in the manner in which they wanted to, and so therefore they had a contingency plan in place. But I don't know that we'll ever know the answer to why did it start this way. But I thought it was really interesting.
Well, Sarissa, I have to ask, when people do that, whether it's marking or clipping clips, screenshots in real time in front of the jury, does that make the jury kind of think about what's happening more? I mean, if you show someone a picture, they'll have a thought right away. But if they're stopping, doing this process in front of them, does that make the jury give the jury idea of saying, oh, I didn't see that before. Oh, maybe I should think about this. Like, how does that impact the jury?
So the jury, the amazing, terrible, wonderful, horrible thing about trial work is that you never know what's in the mind of jurors at any given point, right? So some jurors might have the same question that I did. Why did they try to proceed in that manner rather than a different manner? Some jurors might say, why are you wasting my time? Some jurors might say, oh, I like the way that he was doing it. I'm sorry that we can't proceed. We have no idea what the jury or each individual juror is thinking. And to the extent that they were, worried that, oh my God, this is taking forever, great for those jurors, to move this along quickly. But then if you have the ones who are like, oh, I really liked the way that this was going, this made a lot of sense, then that kind of stinks because, they don't get to go forward in the manner. But we have no idea individually how they're responding to it.
Andrew, I have to finally come to you to ask you also about this situation. What was your reaction to it?
My first thought was when Mr. Becker made the objection. My first thought, I was reminded of the movie Animal House, where they said, "Hey, they can't do that to our pledges. Only we can do that to our pledges." To Tanya's point, the prosecutors do this all the time, and the fact that suddenly he's concerned that this is taking too much time, I don't know why the defense was proceeding in that fashion. I have to believe it's strategic, but it's routine for somebody to create an exhibit in trial just using the testimony. We do it all the time using whiteboards or markers, and we'll just like, okay, your testimony is this, give me the timeline. I've created timelines and just you mark it as an exhibit so you can submit it to the jury. And so it's not abnormal. The fact that he objected as it's quote unquote cumulative, it's like we're all going to see these videos 1,000 times by the time it's done. And the fact that the defense has an expert that can break it down into a way that's easier for everybody to understand and to get to the nuances, it sounded to me like, hey, we don't want the best evidence. We want it people to not see this, and because it's bad for us. And it sounded like I don't know. I mean, if the job is to get to the truth, then why wouldn't we want to break it down and see it in a way that we can understand? Like when Chris Schurr's on the street with Patrick, it's like things are happening fast, and thank God we've got this technology now where we can go back and look at stuff and see what happened. Like, where were the prongs to the taser? I mean, because the experts made certain arguments. Well, let's see if we can apply the facts to what they're saying. And so I've have found that expert to be very helpful in just understanding. And I like how he puts all the videos together and explains the reference points. And so when I heard the objection, I just kind of chuckled to myself. It's like, yeah, okay, you don't like it, so you got to find a way to object. So they'll fix it, and we'll get to see it again. So,
and I have one. Sorry, I have one last question for you all, and that's just your reaction to the whole entire case presented. You know, they have rested their case. You know, I know that we won't really know who did the best or be able to compare everything until essentially the verdict. But now that we've seen the prosecution's whole entire case, what is your now reaction to what they have presented and going forward with now the defense? I'll start with you, Andrew.
Well, first of all, you know, the big question is whether or not the prosecution proved to the jury beyond a reasonable doubt that it was not justified. And the problem in self-defense cases is it's a double negative. And so it's like when a juror is thinking about it, it's like, well, was he justified or not? And from Chris Schurr's perspective, man, it's an argument to be made that they never proved beyond a reasonable doubt. If I can now put on evidence to show in my favor that in fact we can prove that it was justified, well, that helps the jury reach that conclusion, because you're not required to claim that you can prove that you are justified. The prosecution is required to prove beyond a reasonable doubt that you were not justified. And so I think now what they're going to do is they're going to really attack that in the defense. And so I'm looking forward to seeing how they do that going forward.
And Tanya, I also want to hear from you about your reaction to the prosecution resting their case, what they presented, and now what you look forward to with the defense.
Yeah, similar to Andy, I think in this particular case, there's no argument that Christopher Schurr caused Mr. Leoya's death. That's not the issue here. And what his state of mind was as far as was this an intent to kill or cause great bodily harm. But I'm looking forward to how the defense now presents, even though they don't have the burden of proof, with respect to presenting the case of self-defense. The self-defense jury instructions in Michigan are very favorable to a defendant raising the defense, right? And they say that we have to look at what the defendant's subjective state of mind was, and then we look to see if it was objectively reasonable. And so it's not surprising to me that the prosecution spent a lot of its case trying to establish that his response, Mr. Schurr's response, was not a reasonable or proportionate response, and trying to knock down this idea that he was reasonable in his calculation that he needed to act in self-defense. So I'm really looking forward to how the defense presents that other side of self-defense, what Mr. Schurr was thinking, why he thought he was at risk of imminent death or great bodily harm, and how the defense expert witnesses, I anticipate they're going to bring in experts, will help establish that.
And Sarissa, I also want to get your thoughts on what the prosecution has presented and what you're looking forward to as defense begins their case.
Well, I think the prosecution did what they intended to do, in that they tried to present enough evidence to a jury for the jury to find that Mr. Schurr didn't act in self-defense. You know, they tried to take it piece by piece, and only the jury, you know, will determine if that's the case. What's interesting and going to be interesting at this point for me is to kind of go back to what we talked about yesterday, which is, are they able to establish Mr. Schurr's fear of what was taking place without Mr. Schurr testifying? That's, again, another strategic, interesting point just from a defense lawyer's perspective when you're watching a case like this, and you just, you know, it's always at risk to put your defendant on the stand. We talked about that yesterday, but in a self-defense case, most times you really need to. So are they going to be able to get what they need without Mr. Schurr testifying, or will he have to be put on the stand? So that's really what I'm looking forward to seeing as this progresses.
And I know I said that was my last question, but as you know, we are on a 30-minute delay, and my producer just told me something very interesting that just happened in court. I'm hoping to get yours all, you know, initial opinions for what I'm about to say. Essentially, the defense wants to include evidence that would speak to Leoya's intentions and character. The judge has said that that is not relevant to the case. This is the second time that the defense has tried to add in things about Leoya's character. Is that normal? Is it strategic for when they're doing it now that they have their own case to present? I just want to know your initial reactions to just hearing that little blurb of that. I'll start with you, Sarissa.
So the defense is going to do everything possible to try to get in character evidence about Mr. Leoya. I mean, that's what you want to do, but rules of evidence kind of preclude that from happening unless you have certain things that come up that allow you to do it. And so in the same way that we were talking about motions earlier, that you try everything that you possibly can to try to represent your client in the best way possible. And so now they're trying this, and again, they're trying it now. And if they get denied, it's possible that something might change in the future and they might try it again. There's no harm done in trying. What the judge decides, the judge decides. But if they have an open door, they're going to take it, because that is evidence that would be helpful for the defense if it was able to be presented to the jury.
Tanya, I want to hear your take on this latest opportunity, I guess, that the defense is trying to bring in more evidence of Leoya's intentions and character.
Yeah, picking up where Sarissa left off, of course, the defense is going to try everything they can. That's their job, to zealously represent their client. And remember, when the defense is self-defense, the reputation of the victim's reputation for aggressiveness is admissible. But in Michigan, we've seen the courts rule that the defendant has to be aware of it, right? Because if the defendant's not aware of it, how does it affect the defendant's state of mind in thinking he or she has to act in self-defense? So just like it was ruled on earlier, if something comes up where it becomes evident that Mr. Schurr might have been aware of some of Mr. Leoya's prior record, then it all becomes fair game again. And I would expect the defense to continue trying to get to that evidence.
And finally, Andrew, I would love to hear your take on this as well.
Well, let me ask you this question. When they did it, was the jury present or not?
It's unclear at this time. We're not sure, because obviously we're on the delay as well, but it is unclear.
Okay, well, because that changes my analysis a little bit. If the jury's not present, they're just bringing in another request to do it. But if the jury's present and they try to do it, well, what they're communicating to the jury at that point in time is, hey, there's stuff here you're not allowed to look at. Wouldn't you be really curious to know what it is? And jurors will oftentimes grab onto that stuff. And so that's like one of those things a trial attorney will do strategically and broach the issue in front of the jury, just to plant the seed in the jury's mind that, hey, the court and the prosecutor's keeping stuff from you, that we've got the secret thing that you'd love to know about, but you can't because they're stopping you. And so that's a little trick that trial attorneys will use. And so that's why I asked that question, if it's in front of the jury or not.
Well, we just got word in my ear that the jury was not in the courtroom when that was said. So I guess what's your reaction to that?
Well, then they're trying everything they can, and going back to Tanya's point about, hey, if the guy has a violent past and it's known to Officer Schurr, then that changes the analysis. And so, like for example, let's just say that when he pulled up, he didn't know who he was. That's the whole thing. Like, but we don't know whose plate was on that vehicle. So all he said was it's a wrong plate. So I don't know if Patrick's name was attached to the plate or if another person's name was attached to the plate. But it's possible that his name was attached to the plate, and then if he knew that he suspected that that's the person that he's dealing with, and that person has, a violent criminal history, it would likely show up on lien. Here's the other possibility: like, what if the plate comes back to somebody else that's not Patrick, and that the person that it comes back to does have a lengthy history of criminality and violent offenses. And now you think you're dealing with that person and not Patrick. I mean, so we don't know. No one has ever said who the plate came back to or what individual. And certainly we don't know what Officer Schurr knew because he hasn't testified and his Garrity statement hasn't been released. And so we don't know.
Well, I appreciate you all coming on again to talk with us. A lot to discuss, and we still have a whole nother case to listen to with the defense. Thank you again for all joining me today.